it takes me a while and I'm just like, I can't hear anyone. What's going on? And then people are like, I think you're on mute.
It's weird seeing Brenna out there.
Yeah. All right, everyone. Happy, I believe this is a happy Tuesday. So I do have some pleas that are ready. So let me know if you're here. Are the parties here for Albert Lemon?
I'm present, Judge. He's a prisoner.
All right, let me see if we.
Present, Your Honor.
All right, who's the prosecutor on Albert Lemon?
That would be
Is there a prosecutor available to take this plea?
was Miss Sparks.
Judge, is it a recommendation?
Oh, let me see. I can walk you through it.
Okay.
All right, thank you. Awesome.
There is a matter that's not on the plea papers, Judge. I'm not sure he's aware of, but it's a little unusual.
All right.
I have a really simple one, Your Honor.
Just one moment. Brittany Sparks?
Yes, Judge.
There she is.
All right, she's in the courtroom, so we're going to get feedback.
Do you need a mic here? You can use that mic. Okay.
Yeah, the only thing I'm not doing now, like jumping. That's so many.
All right, so there's some issue with the paperwork, Mr. Valachek, or something that's.
Well, Judge, the state has no objection to credit for the defendant's back time on another case, but we're not sure you would go along with that. It's really, not in the plea paperwork.
Well, if he was in custody at the time this case was pending, I will give him credit for that. If he was not in custody at the time the case was pending, then he's not going to receive credit. So if he was in custody, then he'll receive credit.
Is that okay with you, Mr. Lamont?
Yes, sir, I was in custody the whole time.
Okay.
All right, we're going to go on the record. Court is calling 2021 CR 1796, State of Texas versus Albert Lou Lemon. Can I have parties announced for the record for the state?
I can do Michael Villarreal for the state.
Right, for the
No,
defense.
unmute her.
Michael Valachek for the defendant.
And are you Mr. Lemon?
She isn't eating. She has
Are you Mr. Lemon?
Yes, sir.
We're proceeding by video because of the pandemic. Any objection from the state?
None from the state.
Any objection from the defense?
No objection, Your Honor.
Mr. Lemon, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Velichek, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lamone, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're proceeding on count 2 and waiving the repeat enhancement allegation. Is that correct?
That's correct, Your Honor.
Any objection?
No objection.
Mr. Lamone, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 2, you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. For any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lamone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Oh, yes, ma'am.
According to the plea bargain, the state is proceeding on count 2. Your punishment is to be assessed at 3 years in the prison. There's a $1,000 fine. There are no applications. The state will take in consideration grand jury number 7355547, county court cause number 653801. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then, Mr. Lamone, to the offense count 2, how do you plead guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, Your Honor. At this time, state offers safety exhibit number 1 and its attachments.
Any objection?
No. No objection.
Mr. Lamone, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, Mr. Lamont's been locked up for several years now on various offenses. He likes to get this behind him, move on with his new life, and just put a stop to this criminal behavior he's had in the past. We would ask that the court give him credit for the 172 days that he served on this case, and in addition, the 365 days he served in cause number 16CRF0014, styled the state of Texas versus Albert Lemon from Kleberg County. That's Kleberg.
And can you tell me, was that a case where he was, where this case was pending, the incident case was pending while he was in custody on that case?
I'm not sure, Judge. I understand the state has no objection to this. It was a DWI with child in the vehicle is the nature of the offense.
Well, I will give him credit, but I will only give him credit for it if this were an open case at the time he was in custody. Do you understand, Mr. Lamont?
Yes, ma'am. When I got this case, it was open. It was.
All right, so Mr. Belichick, if you'll let the clerks find out if that case were, if this instant case was pending while he was in custody, then the court will give him credit. But if this case were not pending, then the court is not going to give him credit. So Mr. Lamont, on that, your attorney will have to provide that information to the clerks. And if that is the case, then the court will give you credit for it.
Yes. I've been communicating with the clerk today, Judge. I don't know. We'll find that out.
Okay. All right, then the court will, as previously stated, the court found there was sufficient evidence to find you guilty. The court is finding guilty. Sentence you to 3 years in TDC, credit for any time served. There's a $1,000 fine, time, and money will run concurrent. Taking consideration grand jury number 735547, county court cause number 653801. And the defendant is to receive credit for time served and cause number 16CRF0014 if defendant's instant case, which is cause number 2021CR1796 was pending. Is there anything else from either side with regards to sentencing?
Nothing further from the state, Your Honor.
Not from the defense, Judge.
Mr. Lamont, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Lamont. I've included in, it will be included in the judgment that you'll receive credit for that time if this case were pending at that time. You understand?
Yes, ma'am. Thank you very much.
You're welcome. We got the record. Mr. Lamont, next time you think somebody has your tattoo gun or they've given it to somebody else, you know, the best thing is just call the police. Don't take the law into your own hands.
Yes, ma'am.
And I think they would say at the end of G.I. Joe all the time, the cartoon we would watch growing up. So don't take the law into your own hands.
No working on that.
All right. Have a good one. Okay.
All right, bye.
Bye-bye. Norma L11 can go back. Who has Jonathan Pena?
I do, Your Honor. James Hunt.
Repeat that. You have to put it on mute, sir.
And is Pena in custody? All right, who's
He
the prosecutor on Pena?
Joe Ray.
All right, the court is going to call 2022 CR 1225, State of Texas versus Jonathan Pena. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
James Hunt.
All right, and are you Mr. Pena?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Pena, I'm showing you what's entitled Defendant's Consent to Enter Plea by Video Conference. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review that discovery with your client?
I have, Your Honor.
Court will find that state is in compliance with discovery. Mr. Pena, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
I did, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Pena, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you charged with evading arrest, detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Pena, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine, probated. State recommends community supervision. They will take in consideration 2022 CR 1226. There's restitution to Francisco Gaona, Gaona, and there's to be no contact with Francisco Gaona. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
It offers State's Exhibit 1 and its attachments.
Any objections?
No, Your Honor.
Mr. Pena, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, off the record for a moment.
I still have to have a camera. You see how she has all of us right there? So this is mine. This is mine. This is happening a lot. Going forward, that I'm gonna be here more. Right. Then back.
Oh, no, you're fine. All right, Mr. Garcia. Everyone, I'm going to open up breakout rooms. Do not go to a breakout room unless I specifically call you by name and assign you. All right, Mr. Garcia. I'm going to send you to breakout room number 1, and Mr. Hunt, I'm going to send you to number 1 to speak with the clerk.
Yes, Your Honor.
And Joe Ray, if you will go to number 1, please.
Yeah, I was in the picture. This is what it was. This is what I was doing.
Okay. All right, thank you. All right, everyone, just give me a moment. Okay, everyone, just give us a moment. Who is the parties on Rita Gomez? Rita Gomez.
John Young, Your Honor, and Joe Ray Garcia, whom you just sent to another room.
That's okay. We have plenty of prosecutors on here who will join the fray. Where's Rita Gomez?
There she is.
How are you
Moto
gonna
G
sit?
Pure.
1-0.
I'm doing good.
All right, can I have a prosecutor, please?
Marcus.
Thank you. Ms. Gomez, you need to find a seat and be stationary, please.
Okay.
Thank you.
I'm sorry.
No problem. Court is calling 2021 CR 6154, State of Texas versus Rita Nina Gomez. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
John Young.
And are you Ms. Gomez?
Yes.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Ms. Gomez, I'm going to show you what's entitled Defendant's Consent to Enter Plea by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledged. Mr. Young, have you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Gomez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Do.
State, it appears you're proceeding on the indictment as presented. Is that correct?
Yes, Judge.
Gomez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,000 fine to be probated. State recommends deferred adjudication. Take in consideration NIMAG number 640758. No contact with Christian Bernal, Bernal, and $114 to Bear County for drug testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Is, although my client has told me she does not know who that person is.
Okay. Well, you will have no problem not contacting them. Defense, I'm sorry.
That was
state,
very much my attitude, Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Yes.
All right, next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting a deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, and IOP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, the state offers states exhibit 1 and its attachments.
Objection.
Ms. Gomez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, can I see parties in breakout room number 1, please? All right, we are back on the record. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has begun getting her own treatment already. She is currently on methadone treatment, and I know she's employed, and I think that she's probably on track better than most people to be successful with probation.
All right, Ms. Gamez, do you have any children?
Yes, but they're not in my custody.
Is Child Protective Services involved?
They already closed the cases.
So were your parental rights terminated?
Yes, ma'am.
Are the children with family members?
Yes, ma'am. Except for my third one, he got adopted.
Okay.
But she keeps him close to the family and sends the family pictures of him and stuff like that.
All right, who is Jake Hartman?
Jake Hartman. I don't know who that is.
All right, these were people who were in the vehicle, I guess. All right, so this is what are you employed?
Not right now, but I'm waiting for a job to call me right now back.
So how are you supporting
I do
yourself?
house cleaning now.
How are you supporting yourself?
I do house cleaning every now and then.
Who lives with you?
I live with my boyfriend.
What's his name?
Joseph. Sorry, ma'am.
I'm sorry, what's his name?
Joseph. Joseph.
I mean, who is he?
Her
Joseph
last name.
What is his last name?
Sanchez.
Does he have a drug habit?
No,
How long have you been with him?
it's going on just like 5 months. But it's kind of not working out, so
All right, does he have any children?
no, ma'am.
Are there any children in the household with you?
No.
All right, this is what the court is going to do. 2 years deferred adjudication, $1,000 fine, probated. Take in consideration NIMAC number 640758. There should be no contact with Christian Bernal. $114 restitution to Bexar County for laboratory testing. Proof of employment within 15 days. There should be no employment as a home health care provider or with minors. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the vaccination, but if you do, 40 of those hours will be waived. Parenting classes, and I guess Rebecca, the triple P. There should be no unsupervised contact with minors.
Okay.
Intensive outpatient treatment with probation. The UA hotline. We'll do a referral to felony drug court. Regular reporting by Zoom or in person. So if you can't report by Zoom, it'll have to be in person. We're going to do random field visits 2 times per month.
Random
Rebecca,
what, ma'am?
I'm sorry, what?
Random what? I couldn't hear you the last part.
Field visits.
Okay.
Rebecca, is there anything else that she needs?
Judge, did you say the no harmful, no employment with as a home health care?
Yes.
Okay, that's it.
Is there anything else that you need from the court, Ms. Gomez, in order to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Gomez, you're gonna have to stop using drugs. You're gonna have to start accepting responsibility for the children that you have. If a relative is taking care of those children, it still would help them out if you were to pay child support. Do you understand?
Yes, ma'am.
All right, I'm gonna send John, I'm gonna send you to breakout room. If you could wait in breakout room number 1 with your client, probation will be there shortly.
Your Honor.
Thank you. All right, the people who are on Pena,
Yes, Your Honor.
all right, we're gonna go back on the record. Brenna, I believe I stopped on the waiver and consent and I accepted it into evidence. Is that correct?
Let me check, Judge.
Thank you.
Yes, that's where you stop.
Thank you. All right. So we're back on the record in 2022 CR 1225. The court is reviewing State's Exhibits 1 and attachments for sufficiency. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I believe the plea bargain is appropriate and he can benefit from probation.
All right, Mr. Pena. How old are you?
20 years old, ma'am.
I'm sorry, how old?
20?
What did you
20
say?
years old.
20, okay. Do you have any children?
I have one daughter, ma'am.
How old is she?
She's a year old.
And where is she now?
She's with the baby mom's mother, so her grandmother.
Let's not say baby's mother. Let's say the mother of my child. Let's say the grandparent. So basically, you're not raising your daughter and neither is her mother. Is that correct?
Yes, ma'am.
So how far did you go in school?
I actually, I had stopped going to school in 6th grade due to the fact that I had went to TYC, and from there I ended up getting put in 9th grade. They had skipped me 3 grades, and then I earned 2 certifications in welding, and I got a scholarship to welding to the Tulsa. And I aged out of I did up until I was 16 in TYC, and then I got out and did a year in CPS, and then I aged out at 18 out of CPS custody. And I was with my baby's mom.
The mother of your child.
The mother of my child. Till I was like 19. We just recently separated, and so I was with her until I got out of CPS, and then so right now it's kind of like a rough beginning, I guess you could say, starting off again, because it's like starting my life over again in a way, because I've only been out of the system for like out of CPS and TYC for like 4 years, you know what I'm saying?
So where are you going to be living? Do you have a place to live?
I'm gonna be living at my sister's house. But
Does she want you to live with her?
yes, ma'am. We spoke today when I went back after 11 when I had told her, and she was fine with that.
And where is your mom or your father?
I don't talk to neither one of them because they are, I guess they're doing their own thing at the moment, and I'm not in communication with them at the moment, ma'am.
All right. Are there any drug issues with you?
No, ma'am.
Gang membership?
No, ma'am.
All right. This is what the court is going to do. Court is going to sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine, probated. Take in consideration 2022 CR 1226. There's to be no contact with Francisco Guyana. 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not forcing anyone to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be parenting classes with compadre, e-compadre. If you complete those parenting classes, the remaining hours will be waived, but you must complete parenting classes. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. We'll do a gang evaluation. Regular UAs, field visits, 2 times per month, random. Rebecca, is there anything else you need?
No, ma'am.
Mr. Pena, is there anything else you need from the court in order to be successful?
No, ma'am. I really appreciate it, ma'am.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you want to know the definition of weapon or ammunition, you need to speak to your attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Pena, you have a young child. I don't know if Child Protective Services is involved or not, but it sounds like you and the mother of your child decided to have a child and not take care of that child and depend on someone else to do that. That is your responsibility. When you have children, you cannot send them off to Travis Park and tell them, go forth and raise yourself. Someone has to do that. And right now it's the mother of your child's grandmother. You need to step up. You need to start paying child support. And when probation goes over conditions with you, people don't pay attention to it, but there's a condition in there that says that you are responsible for supporting your dependents. And supporting your dependents doesn't just mean I love my child. It means providing for them financially. Because while you're at the Bexar County Jail, I know the food isn't great, but you're still eating. And you're just assuming that someone else is feeding your child, and really that's supposed to be your responsibility. You understand?
Yes, ma'am. I completely understand.
All right, good luck to you. I'm going to send you to breakout room number 1. And Rebecca, you can go to breakout room number 1.
Thank you, Judge.
You're welcome. And let me find Mr. Pena on the Zoom. And Mr. Hunt, you can go to number 1, or either you can be excused.
I believe my client understands the conditions.
All right, thank you.
Thank you, Judge.
Excuse me, Judge, can you make me a co-host, please?
Yes, I will do that. All right, Michael Sawyer.
I am unmuted. Good afternoon, Your Honor.
Good afternoon.
I did report in your court this morning, but I was set on an in-person hearing in the district court. That's where I was all morning.
Okay. And what is happening with Stilzik?
Judge, what we have done is this: the state turned over all the real parts of the case that contained what they thought were the forgeries. I've had my client review it all. We've isolated the forgeries in question. We're now getting the services of Jeanette Hunt, who is a handwriting expert, to do an analysis of the handwriting of the so-called forgeries to determine if they're really forgeries, number 1, and number 2, if those signatures belong to Lori Stelzig.
All right, when is this going to be done?
Judge, I've not used a handwriting expert a great number of years. Generally, it takes about 35 or 40 days. She is local. She's based out of San Antonio, and she's recognized in federal, state, district courts, and other states also. So she's got all the right credentials. She's the one I'm looking at.
Well, have you already retained her?
I've already contacted her. We're setting up the consultation, and the funds will be there to hire immediately.
All right, so Ms. Ferguson, on Stilzik, can we have a reset for 2 weeks so I can see where you're on that, Mr. Sawyer?
That would be great, Judge.
And if I could have that in the chat box. Okay, we're going to come back on April 6th.
April 6th?
Yes.
Thank you, Judge.
Thank you. You're excused. Tell your brother I said hi.
We came in to see you last week, and you had a courtroom full of people. Couldn't even look up. We're going to wave at you.
Oh my gosh. Tell your brother I'm disappointed.
Well, next time it's a slow day, we just have lunch or something. Enjoy the day.
Okay. All right. Thank you. Have a good one.
Bye-bye, Judge. You take care.
All right. Eddie Bravenik. Eddie Bravenik.
You won't let me unmute.
All right. Who's your client?
Judge, can you hear me? I'm sorry. It took me a second there.
Yes, I can hear you.
Excellent. I'm sorry.
Who's your client?
David Earl at Black. It was a contested MTR.
All right. And where is Mr. Black?
Judge, I believe he's in Disneyland.
Well, it's a magical place. Who's the prosecutor?
I can jump in there. It was me and it was Brittany and I, but I can speak.
All right, we're going to go on the record. Court is calling 2018 CR 6799W, 2018 CR 6798W, 2018 CR 6830W, State of Texas versus David Earl Black. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Eddie Bravanek.
We're proceeding by video because of the pandemic. Any objection from the state?
None, Judge.
Any objection from the defense?
No, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 2:59 p.m. Deputy Laura or Deputy Mejia, has there been a David Earl Black in the courtroom?
No, Your Honor, he has not.
And I received reports that the defendant did not appear by Zoom. Mr. Bravanek, has your client, Mr. David Earl Black, appeared at all today on Zoom?
No, Your Honor. And I have done my absolute level best over the past week. I've called his mother, I've called his ex, called his, I believe, his sister, and I even called his cousin. And I've done so multiple times to try to reach him, and I have been unsuccessful.
All right, state.
Yes, Judge. At this time, Judge, based on his absence today, the state would move to ask for all of his bonds on all 3 cases to be revoked and for you to remand him without bond.
All right, that'll be granted. Mr. Bravanek, if you're able to get in touch with your client and your client appears, the court will reconsider. But for now, in each case, the court is going to grant the bond forfeiture and remand your client without bond.
Judge, I have a request for the court. May
Yes.
I present it to you?
Yes.
So Judge, he apparently cut his monitor and ran. I put significant time, effort into this guy because I believed into him. I talked the offer down from a prison time to a life skills course. And just honestly, I am so mad at him that I think I would be ineffective in representing him, which I know sounds unusual, but it's the way I feel. You know, I went out on a limb for this guy and he cut off the limb. Well, I don't normally request this because I don't think I'd be effective. I'm going to ask if the court would let me off.
Once your client is in the custody, the court will consider.
All right. Thanks, Judge.
All right. Thank you. All right. Raymond Martinez.
Yes, Judge. I likewise had 2 cases this morning, but I was in person in the courthouse. So I asked the court to recall my 2 cases for this afternoon. Joseph Ramirez and Martin Lopez.
All right, let's start with Martin Lopez. Where is Mr. Lopez? You're on mute.
Sorry, Judge. He was logged in at 2 o'clock and he said that after about 20 minutes, he got kicked out. But I don't know if that was just a technical issue or.
That may be a technical issue.
I'll get him logged back in, Judge. He was there.
All right. So where's Mr. Joseph Ramirez?
He's in custody, Judge.
How you doing, Your Honor?
I'm doing great.
Awesome.
Okay, let me find, there you are. All right, what is happening with Mr. Ramirez?
Judge, on Mr. Ramirez, I was just retained last week. I did file motions to set bond because he's remanded on, I think, all of his cases. He did not miss a court hearing. I think his bondsman got off strictly due on payment issues. So we're asking the court to set the bond at the same amount it was set before, since he hasn't failed to.
So you've been retained?
Yes.
All right, his attorney, Matthew Finch, filed a motion to withdraw.
And I've communicated with Matthew that I was retained last week, Judge.
All right, thank you.
And I am
Have
happy
you
to
discussed the bond issues with the state?
I have not, Judge. I've been waiting for a prosecutor to become available.
All right, who's the prosecutor on Joseph Ramirez?
I can go talk to Raymond.
All right, then Mr. Martinez, if you'll go to the breakout room, state if you request that he go to a breakout room.
Yes, Judge.
All right, Jocelyn Andrews.
Your Honor, this is Matthew Brown. May I approach before you move on?
I'm here.
I received an email from Norma Ferguson today to be present on Joseph Ramirez. And I am here, and I think it's probably just a mix-up.
All right, I'll send you to a breakout room, number 2.
Thank you.
All right, Miss.
Judge, did you call me? This is
Yes, I
Jocelyn
did.
Andrews.
We're going to take up your matter right now. And Ms. Ferguson, if you go to breakout room number 2, please.
Yes, ma'am.
And Ms. Andrews, who is your client?
Aaron Gordon, he should be present in the courtroom, Your Honor. Excuse me.
All right, if I could have Mr. Gordon come forward, please. And who's the prosecutor on Gordon?
This is the general area.
It's Brittany, Judge.
And I think he is here on one case. Okay. All right, the court is calling 2021 CR 3213, State of Texas versus Aaron Michael Gordon. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Jocelyn Andrews.
And are you Mr. Gordon?
Yes, Your Honor.
We're proceeding by video because of the pandemic. The court will note for the record that the defendant is in the courtroom. Any objections to us proceeding by video?
No objection from the state.
No objections from defense.
Any objections, Mr. Gordon?
No, ma'am.
All right. According to the plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. The state opposes your applications and the state is taking 2021 CR 3214 into consideration. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
Any objections from the state or the defense?
No objection.
No objections, Your Honor.
All right, state, you're opposed?
Yes, Your Honor.
State, you can begin.
No.
Judge, we have no witnesses. We just have argument.
All right, defense?
No witnesses, just argument, Your Honor.
All right, state, I'll hear your argument.
Yes, Judge, we are asking that you deny his application and sentence him to 6 years in TDC. As you can see from the PSI, he has a long history of criminal offenses. Most of those offenses are gun related, with his most recent prison trip being 5 years on the aggravated assault with a deadly weapon. He has had several attempts to be successful, or he's had several chances to be successful on probation, and he has not done so. He is also a self-admitted member of Gangster Disciples.
All right. You're on mute, Ms. Sparks.
Judge, because of all of those reasons, we don't believe that he would be a good candidate for probation. That's why we're asking you to sentence him to prison.
All right, defense.
Your Honor, I'd ask that you give Mr. Gordon an opportunity on probation. Jail is always an option. If he fails at probation, certainly prison, he can always go to prison. Your Honor, he's 30 years old. I believe I think he's learned his lesson, finally. And it took him some time. He's not been an angel, but he has done very well while awaiting the hearing and the sentencing for this case. The incident occurred in January of 2021. And so he's been monitored by pretrial services, et cetera, during that time. And he's done well. He lives with his girlfriend and 4 children. All 4 children are hers and only 2 are his, the youngest 2. And they are 3 and 1 year old. He is the caretaker for the children. He keeps the children during the day and works at night. The girlfriend's schedule is opposite, so she can keep the children while he's at work and vice versa. Your Honor, he's a valued member of the community. I sent approximately 10 reference letters. Excuse me, I don't know what's happening with my voice. Excuse me. I sent approximately 10 reference letters to Mr. Groomer this morning. Aaron is well liked in the community by family and friends, including in-laws. And everyone talks about what a nice guy he is. And I must admit that he has always been extremely pleasant and respectful when talking with me. But they talk about what a nice guy he is and a dedicated father and how good he is with his children. Unfortunately, he has been off from work for the last couple of months because he had COVID. And by the time he was clear of COVID, then he wasn't able to go back to his job. So he's waiting on them to call him back. And that's already put a financial strain on the family. So his girlfriend is supporting him and the 4 children. So his help is very much needed, at least physically, until he can at least get back in the game and help provide for his family financially. He knows he was wrong. He is extremely remorseful. He's also afraid, Judge. He doesn't want to go to jail. He's afraid that because of his history and his record that you might just send him to prison. I assured him that you were fair and that you would consider all the circumstances, but he is afraid. He is a family man, loves and respects his family. Unfortunately, he and his dad were shot a couple years ago in a drive-by, and the perpetrators are still at large. And that was the reason for the gun. Not a good, it's a reason, I understand the reason, not necessarily a good reason, and he knows he had no business having it, but that was the reason he had it. He fears for his safety and that of the family. I think they did move from that residence where they were staying. He is trying to be a better man for himself, his family, and do the right thing. And he's been successful, for the last year or so. So I'm asking the court to please give him an opportunity on probation. Obviously, we would prefer deferred, but regular probation is certainly better than prison time. And we'd ask that you take all of these things into consideration. He doesn't have a drug problem. He doesn't have a mental health issue at this time. It appears that these issues have been addressed and or resolved. He is trying to get SSDI again. He lost that when he went to prison the last time because of hearing loss is why he was qualified. And he's trying to get that again. He's doing everything he can to help his family. And that would be it, Your Honor. Please consider his request for probation.
All right. I don't have any copies of any letters that were sent. So I don't know where the letters are, the letters of support.
Probably with Mr. Groomer then. Shall I forward them to you, Your Honor, to Norma, or I don't know if Brittany has them readily available or.
I can forward them to you right now, Your Honor.
All right, thank you. If you can do that. And then Mr. Ramirez, Joseph Ramirez.
Yes, ma'am.
I'm going to send you to breakout room number 5. Your attorney wishes to speak with you.
Yes, ma'am.
And while I'm waiting for that email, we're off the record, Brenna. Mr. May, what is happening with Mr. Barnes?
Yes, good afternoon, Your Honor. We were supposed to have a bond reduction hearing this afternoon, Judge.
All right, who's the prosecutor on that?
Judge, if I may, could I have a couple of minutes? I think Mom, she's at work and I have to, she wants to testify. So could I have a couple of minutes to get Mom on Zoom so she can be able to testify?
Sure. Yes.
Thank you, Your Honor.
Fernando Cortez.
Yes, Judge. I have Jonathan Trevino. I'm coming back from this morning. His 2 felony cases requiring a GPS have been dismissed, Judge, and I filed motions and emailed them to your court coordinator requesting the court respectfully requesting that the court remove the GPS device of the condition of bond on those two cases.
Okay, I don't see your client. Your client is in the dark.
He should be on, Judge. He was in there in person this morning for the trial setting, and I told him to log on also.
No, I mean, it's just a black screen. So I don't know if you can talk to him. Hey, but you know what? It's a Tuesday,
Well, he
not
was
a
using,
Monday.
Judge, he was using a different phone, and I don't know if he's struggling because I had to send the meeting ID to a different phone from what he called me from. And let me see if he can get this thing on.
All right. Gary Churak.
Yes, ma'am.
All right, let me have you come forward. All right, who are you with, Mr. Churak?
Eddie Medina.
What is happening with Mr. Medina?
It is a sentencing this morning or this afternoon, Your Honor.
Who is the prosecutor on Eddie Medina?
Michael Villarreal, Your Honor.
All right, we're going to take this matter up while I receive the other information. All right, the court is calling 2021 CR 6391, State of Texas versus Eddie Medina. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Gary Chirac for the defense.
All right, we're proceeding by video. I'll note for the record that the defendant is in the courtroom and we're proceeding by video because of the pandemic. Any objection from the state?
And from the state, Your Honor.
Any objection from the defense?
No objection, Your Honor.
Do you have any objection, Mr. Medina?
No, ma'am.
All right. The defendant entered a plea to the lesser included offense of aggravated sexual assault of a child. Punishment is to be assessed at cap 15 years in the prison. There's a $1,500 fine, and the state is opposing your application for deferred adjudication. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
Any objections from the state?
We just have one matter of clarification, Your Honor.
Yes.
As far as page 2, the assault bodily injury married case, that was actually a deferred case where it was subsequently dismissed. And I just want to be clear because the 2005 case that was listed also when you had deferred was eventually dismissed, but it also reflected deferred.
Okay. All right, anything from the defense?
Nothing further, Your Honor.
All right, state, you're opposed to the application?
Yes, Your Honor, and we have no witnesses. May we just proceed to argument?
Yes. Defense, do you have any witnesses?
I do, Your Honor.
Who is your witness?
I have a daughter and two daughters and a wife.
All right, call them up, please. Who's your first witness? Would you raise your right hand for me, please?
Yes,
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you can state your name for the record, please.
Crystal Anaya,
All right, could you spell the last name?
Anaya.
All right, defense.
Crystal, in what relationship are you to Mr. Medina?
I'm his daughter.
Okay, and do you have something you want to tell the court?
Yes,
Go ahead.
I would like to. Your Honor, I just want to thank you for this opportunity to address the court on behalf of my sister and I. I'm very aware of the allegations that my father has been accused of, but those allegations are false, Your Honor. So I would like to say a few words. I've had my dad in my life for almost 4 years now. He's been there for every birthday.
A second. Yes.
We're going to object to the narrative aspect of this line of questioning.
All right, that'll be sustained as to narrative.
Okay, do you want to just, in your own words, tell what your father has been to you?
He's just been there for everything, for every birthday, every holiday, every major event. He's been in my kids' lives, my sister's lives, like for almost 40 years now. I mean, he's just my everything. He's my dad.
I have no further questions.
All right, thank you. Any questions, state?
Yes, Miss Anaya, do you have any kids?
I do, yes. I have 2 boys.
You have 2 boys?
Yes.
I'll pass witness.
All right, thank you. Any further?
I have no further questions, Your Honor.
All right, call your next witness, please.
I'm speaking on behalf of her.
You want to call the line? Ms. Medina?
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Could you state your name for the record, please?
My name is Lydia Medina.
And Ms. Medina, what relationship, if any, are you to Eddie Medina?
I'm his wife.
And how long have you been married to Mr. Medina?
We've been married 22 years.
Okay. Do you suffer from any physical ailments? Do you have something that medical problems that he helps you with?
Yes.
And what are those?
I don't drive anymore.
Okay.
Disabled.
Why are you, is there a specific diagnosis?
Yes, I'm legally blind.
Okay. And do you have doctor's appointments and things
Yes,
like that?
yes, I do.
And so Mr. Medina is basically your sole source of transportation
Yes,
and income?
yes.
I have no further questions.
All right, state.
Ms. Medina, do you receive any type of federal benefits?
No.
So you don't receive disability?
Yes, I do. Yes.
How much is your disability a month?
How much is it?
Yes.
817.
Do you receive any other benefits?
No, I don't.
Do you receive any type of medical care?
I have Medicare.
You have Medicare?
Yes.
As far as your husband is concerned, does he work?
Yes.
Where does he work?
He works for Alamo. He's a limo driver for the funeral home.
How much money does he make a month?
It's more like a part-time job, so it just varies.
Okay, and does he receive any type of disability or
Yes, he's also retired.
he's retired?
Yes,
Does he receive benefits from his retirement?
yes, he does.
Okay, but how much money does he bring in a month?
It's $1,273.
So combined, you make about, so both you and him combined make about $2,000 a month.
Yes, sir.
Is there any other person living in your home?
No, sir.
You don't have any children or grandchildren that live with you?
No.
I'll pass the witness, Ron.
The $1,200 a month is social security benefits.
That's his, and then mine is 817.
No further questions.
All right, thank you. Call your next witness, please.
I have no further witnesses, Your Honor.
All right, then the court will hear argument. State.
Yes, Your Honor. So the state is asking that you deny his application for deferred adjudication and that you sentence him to the full 15 years in prison. And that's based on a number of things. First, I think the court has to look at the facts of this case as has been stipulated by the defendant during his plea. We have obviously egregious conduct, any type of sexual touching or interaction with the child is obviously concerning and in and of itself might deserve prison. But the aggravating factors on this case, Your Honor, is that the length of period of time that this occurred, the age of the child when these allegations first started happening, and then as well as the aggravating factors of kind of the threats that he gives in order to prevent the victim from coming forward and her feeling to be able to come forward with the fact that her step grandfather has been touching her for a number of years. Then I think we have to look at the conduct of the defendant during his sentencing, and most specific, obviously, during the PSI. It's very clear that he minimizes his guilt. And what's even more concerning, Your Honor, is you having dealt with these types of cases, your career, you see the kind of classic behavior of him projecting the culpability of this case on the victim and not on him, for him not being able to keep his hands off of as young as a 6-year-old child. And we see him saying things like she's wearing low-cut blouses, and people were telling her about sexual behavior. And if I can go to it specifically. On page 13, where he says she was way ahead of her time and she was sexually advanced. Further, we see on page 14 and 15, him making comments like, if this happened, why didn't she say nothing to her mom? Why wait 4 years to say something? I think the court is well aware when you make threats to a child, nobody's going to believe them, that or something might happen to them if they come forward, that they were being abused. That might be a reason they don't tell their mom. That might be a reason why it takes them over 4 years to make an outcry of what's happening to them. Also, I see that, in looking at this, he doesn't look about what has happened to the victim and how this has had consequences, not just on her life, but everyone who touches her life. If you look on page, sorry, I have it marked, page 12 of the PSI, says, I don't know why she would do this to me. Well, I think the better question, Your Honor, is why would he do this to somebody so young, somebody who's related to him, and most importantly, a child? Can't forget that. And so the last thing I think the court has to look at is the effect that it's had on the victim in this case. And I think the letter that that the victim wrote that is attached to the PSI is very telling of a girl who, so obviously something happened traumatic. From the outside, you can say this is very traumatic to happen to a child, but even she's telling you what effect this has had on her life, that she's been having flashbacks, that she's even gone as far as says that she almost, these things almost made her take her own life. These are things that this child is going to have to live with, not just for the next 15 years, that, the term that we are asking that this defendant serve in prison, but she's going to be dealing with this for the rest of her life. This is going to be a burden on her shoulders for the rest of her life, and not by something that she did, by somebody intentionally, somebody knowingly perpetrating on a child. I think 15 years, honestly, is sometimes it feels like it's not enough, but in this case, it has to be enough based on the plea bargain that the state has entered in with the defendant. And so we're asking that you deny his application and you appropriately sentence him to the maximum under the plea term, which is 15 years. Thank you.
Defense?
Yes, ma'am.
No, excuse me, are you going to testify?
I think he just wants to make a statement.
I just want to make a statement, ma'am.
Well, I mean, I can place you under oath and you'll be subject to questioning. Did you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Defense, do you have any questions?
Do you have a statement you wanted to make to the court?
Ma'am, everything that the gentleman just said and accused me of, the blouse and lowering the blouse, all that time she was coming to our house way before all this has happened. She was coming to our house. She was spending the weekends with me and my wife. She was going swimming in my swimming pool. And as she started to develop, I started telling my wife, she started wearing low-cut blouses, showing her breast. And I kept trying to tell her in front of my wife, you need to pick up your blouse. I don't know why your dad's not letting you wear that, but you need to pick up your blouse. So I did tell her that, to pick up her blouse. Then me and my wife were talking in the bedroom, and she has in the bathroom. The bathroom and our bedroom were kind of adjacent to us. And of course, she started her monthly. And I told my wife, she needs to let us know when she's starting. That way we can have the proper equipment for her. Okay. So she heard it and she came out kind of upset. And I tried to tell her, you need to talk to us and let us know. That way we can have this stuff, because me and your mom, we're grandparents. We don't keep that stuff. Like, I'm 64 years old. My wife is 54. So my wife doesn't have that anymore. You need to let us know what cycle you're at. That way we can have these pads for her. And her spending the weekend with us, you know, my grandsons, I got grandsons, I got nephews and nieces, you know, all this stuff that she's accused of me of doing really, really startled me and my wife and my family members that are back here, my sisters that are supportive of me of all this allegations that I am getting. You know, I've never been in trouble. I've never been in you know, besides what he said about me and my wife had a little conflict. I just retired, and you know, and all this stuff that gentleman is saying about my granddaughter. I love her, as I love my other grandkids. You know, and it just hurts me to hear all that, because if that was the case, my family members wouldn't be here to support me. My daughters wouldn't be here to support me and speak up for me, because they know her also. They called her Tia. They called her, you know, all this other stuff, all these birthdays, New Year's. Me and my wife would go out there, buy her presents. All these, you know, birthdays that she had, she would come over to our house. She would spend the night at our house. She would sit right next to me and show me her coloring that she was drawing and so forth, so on. So, you know, Your Honor, I just don't understand, you know, why she, you know, I can't understand why, because the words, she grew up on the other side of the family. And the reason, like he was saying, that she was well mature, well, she was, because she had aunts that would tell her all these other stuff that grown-ups should only know. And the reason we know is because my daughter that just passed away, she would tell us. She would tell my wife and us that she's well ahead of time. And we kept trying to tell her, don't send her over there. Don't go over there it was the Dimas family. Don't go over there, because, you know, they've been involved with DPS,
Yes.
Police, all over.
All right, sustained.
Anyway,
That's enough.
okay, I'm sorry. That's enough, Judge. Sorry about that. I just had to do,
Judge, we would ask that you grant him probation. If not.
Oh, just 1 second, Mr.
Oh.
Chirac. State, any questions?
I sure do. Say you, Mr. Medina, you talked about all these nice things that you did for Leticia.
Yes, sir.
Did that justify you putting her finger in her vagina?
I didn't do that, sir. No.
Does it?
I didn't do that at all. At all.
Does it
At
justify?
all.
Does it justify you making her touch your penis?
Sir, if I did that, there is if she can tell you whether there's a certain mole on me, then if she could tell you she saw that, then fine. But I'm here to tell you, none of that's happened. None of it. Because my wife.
Okay. So you did all these nice things for her.
No, I didn't do all those nice things for her. I didn't. It was because she was our granddaughter. Me and my wife did it, not just me.
Mr. Medina, how this works is I ask a question and then you answer it, okay? So
Yes,
I'll ask you my next question. My next question is that you did all of these nice things for her that, despite doing all of those nice things for her, your testimony is that she just fabricated all of these things about you.
Yes.
Okay.
Yeah, because I mean, my wife was there all the time. She was there all the time. My daughter, now that she passed on, she was there all the time. My stepson lived with us at that time. I mean, everything happened there at the house, what she's accusing me of. And my wife, I would tell her, she said something in one of them that I bathed her. I never bathed her. My wife is here to tell you, I never bathed her. Never. I don't know where she's got this bathing that I bathed her. I never did.
Okay.
And I would tell my wife,
Mr. Medina.
Answer the question.
Yes, sir.
So again, you did all these nice things for her. She just makes up these allegations. And we're not talking about bathing here. We're talking about things like you putting your finger in her vagina and that you making her touch your penis. She just made all those things up.
I never did, sir. I never did. Okay. I'd be the first one to tell you, yes, I did. I'm a former Marine, sir, and I would tell you right from the get-go, I would never, ever, ever do anything like that to my grandkids. Never. I have.
Mr. Medina, it's a yes or no answer.
Okay.
So you're doing all these nice things for her. She just made up allegations about you putting your finger in her vagina and other things like making her touch your penis. She just made those.
She never did.
Judge,
sir.
I'm gonna object. That's already been asked
never
and
did.
answered numerous times.
Never did, sir.
That'll be overruled. And the defendant has just, if you can answer the question, please.
No, sir.
Mr.
No, sir.
Medina.
No, ma'am. I never did any of that. Never.
So she made it up.
I'm assuming she did, sir, because I'll be the first one to say
Thank you,
I
Judge.
did. If I did all that, I guarantee you, my family members that are back here, my sisters, my brothers, my wife, my 2 daughters wouldn't be here with me at all.
All right,
At
any
all.
follow-up questions, Mr. Chirek?
I have nothing further, Your Honor.
All right, any further witnesses from either side? All
Nothing
right,
further from the
the
defense.
state is opposed to the application. What are you asking for, Mr. Chirek?
Judge, I'd ask that you put him on deferred adjudication probation, and if not, sentence him to the minimum of 5 years.
All right, state, you've already stated what you're requesting.
Yes, Your Honor.
All right, the court is denying the application. The court will find you guilty, sentence you to $1,500 fine, time and money to run concurrent. There's to be no contact with Leticia Demas. Chapter 62 registration, and the court will sentence you to 15 years in prison. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? And just give us one moment.
I'm sorry.
No problem. Did you review this document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Medina.
Your Honor, we have victim impact. Can we just be put in a breakout room for that? Or we can
I will put you in breakout room number 1 to the courtroom. If it's feasible for you to go to number 1, then if you can go to breakout room number 1. If it's not feasible for you to do that, then that will not be done.
Yes, Judge. Can you please put us in breakout room number 1?
Yes. All right, if you can go to number 1, please. Demas. And Mr. Villarreal, I believe you can go to 1. And Marina Winter, if you're there, if you'll go to number 1, please. All right, Mr. Cortez, I believe your client, Mr.
Trevino, Your Honor.
Yes. He's here.
Yes, Your Honor. He was there this morning in person also, Judge.
All right, and who is the prosecutor you were speaking with?
Oh, you always ask good questions, Judge. I'm
These
so
are
sorry.
trick
I have the
questions
name of
I'm
the victim.
asking,
You
right?
got good questions. I just don't know the answer, Judge.
All right, who is the prosecutor on Jonathan Trevino? I think it's a criminal trial division.
I think it was Joe Ray, Judge.
Yes, it was me, Judge.
All right, Joe Ray, Mr. Trevino, it's my understanding that several of his cases, or I guess 2 of his cases have been dismissed. Is that correct?
So my understanding was his family violence case, which was the higher degree, is dismissed or is going to be dismissed today. And that leaves the remaining CTD cases.
All right, so the CTD cases are 2021 CR 9360 and 9359. And the defense is asking, I believe, the removal of the, yes.
Yes, Judge. And we're not opposed to it. I believe that was conditioned for the case that is being dismissed, the family violence, the ag assault.
All right, so if you all will send me the agreed motion, then the court will sign that. And let me give you a setting on Trevino. So
Judge,
just send the agreed motion for the removal of the GPS.
Judge, on the motion you're referencing of the agreed motion, do you want both attorneys to sign off on that?
If you can either send it to me by email, include Mr. Garcia in the email, and Mr. Garcia will write in the email that he's agreed to it, and then they'll forward it to my email.
Yes, Your Honor.
Right. Just give me one moment.
Is that the number you called?
All right, so then that just leaves, let me see, I see where. So this is dismissed.
Actually, Judge, you had him on 2021 CR 6414. That was a condition of that case, which was dismissed on January 4th. In this case, CM 087625 dismissed today. That's another requirement for that case. That's why I submitted two motions.
Well, let me ask you the CM case number.
Yes,
What is
Judge.
that charge?
Pardon, Judge?
What is the charge for that CM number?
That's the aggravated assault.
All right, so I already have the dismissal on that one. So the two remaining cases I have that are open is 2021 CR 9360 and 9359. Is that correct?
That's correct, Your Honor. It's an unlawful carrying and a possession of less than a gram, I believe.
Okay. All right, as soon as you all send that to me, then I will sign it.
Thank you, Judge.
Thank you. And so your trial date is going to be April 19th on that.
Yes, Your Honor. Thank you.
All right, and then Mr. Trevino is excused unless you need him for anything else. Mr. Cortez?
Thank you, Your Honor.
All right, Mr. Trevino, you're excused. You need to be in court on April 19th at 9 a.m. for jury trial.
Okay, thank you, Your Honor.
You're welcome. And who is your other person? Martin Lopez, is that correct?
That's mine, Judge.
Mr. Cortez, do you have anyone else with us?
Oh, sorry, Judge. I was trying to get off. No, Judge, that's all I have, I hope.
All right, thank you.
Yes. Thank you, Judge.
You're welcome. All right, what is happening on Mr. Martin Lopez?
Judge, Marcus Sanders and I had a chance to confirm. We're still at an impasse, so he needs to stay on the trial list, Judge, please.
All right, Ms. Ferguson, can I have a jury trial date for Martin Lopez, please? Just give me one moment. All right, your trial date is going to be April 12th. So Mr. Lopez, you need to be here on April 12th. You need to unmute yourself at 9 a.m. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case. Do you understand?
Yes, Your Honor.
All right, so we'll see you on April 12th.
Yes, ma'am. Thank you, Your Honor.
You're welcome.
And Judge, I can finish up my other case when you're ready.
The other case is Joseph Ramirez, correct?
Yes, Your Honor. Yes, Judge.
Yes, I just have to put him on.
Oh, sorry.
Did you leave him in a breakout room?
I think he stayed in the breakout room. Yes, Judge.
All right, I'm going to need you to go back and bring him from the breakout room, please.
Let me give it a shot.
Robert Guyona.
Good afternoon, Judge.
Good afternoon. Who do you have?
Tagle, Jennifer, CTD. I was speaking with the ADA, Joe Ray, and these are night mag cases in which they need to contact the complaining witness still to give us an offer.
When is that going to be done?
We'd like, I guess, and Joe's right there, so if he wants to say how quick he can do it.
Judge, a 2-week reset's fine. It's CM cases.
All right, Ms. Ferguson, can I have a 2-week reset on Jennifer Tagle, please?
And Judge, the There was an ag assault that got dismissed just a few days ago. I think because of the ag assault, one of the cases, credit card cases, she was remanded without bond. We're asking the court to reinstate that bond.
All right, if you have an agreement with the state on that, then the court will consider it.
We
If
do,
not, we'll
Judge.
set it for a hearing.
We do have an agreement.
All right, then just email that agreement to the court and we'll take that matter up. I need the agreed order.
Need an agreed order.
Yes. All right, Anthony Zamora, who do you have?
Hi, Judge. I've got Louis Tapia. It's a simple permission to travel out of state for his daughter's wedding.
And have you conferred with the state?
For a permission to travel?
Yes.
Judge, that's ridiculous. You're the only one I need to talk to.
No, it's not ridiculous. It's the rules of this court.
Judge.
If there's not an agreement, then the court will make a decision on whether.
Yes,
or not
everything's
to travel.
included on the thing. Yeah, we'll please read it and then you can make your agreement. We'll stand by it. I don't see why I would need to confer with the state over something this simple.
Yes. No.
I
you need to
included
confer with
everything
the-
in there, so you can read it. We'll defer to your judgment.
You need to confer with the state. I'll send you to breakout room number 2. All right, Mr. Martinez.
Judge, unfortunately, Mr. Ramirez is not there. It's an empty room at the jail. I guess I took everything.
All right, let me see. Mr. Ramirez. Do you have all the discovery?
Judge, I'm not sure. I just got hired last week. We did agree on the bond situation. I'm going to send you agreed orders on that. And we also agreed to continue to confer and hope to reach a resolution.
All right, so what we'll do is we'll recall this for discovery. Ms. Ferguson, on Mr. Joseph Ramirez, can I have a 3-week reset for discovery, please? All right, we'll come back on April 11th. And just send me the agreed order on the bond issues.
I will, Judge. Thank you.
Thank you. You're excused.
Thank you, Judge.
Your Honor, this is Jocelyn Andrews.
Yes, just give me one moment. We're going to take you up next. All right, Brenda, have they finished in the courtroom with the breakout room? Thank you. All right, so the courtroom, we're going to go back with Mr. Gordon. Okay, I'm just waiting for the video for the courtroom. All right, we are back on the record. In 2021 CR 3213, the state is in receipt of the support letters that the defense has provided. Any objections to those letters, Ms. Sparks?
No objection, Judge.
All right, any other evidence from either side?
Nothing further from the state, Judge.
Nothing further from defense, Your Honor.
All right, the court will hear argument. State you're opposed.
Yes, Judge.
All right, I'll hear argument.
Yes, Judge, as stated earlier, we're asking you to sentence him to 6 years TDC, given his long history of criminal offenses, most of those being gun-related offenses. His most recent one being 5 years, which is why we're asking for 6 years this time. He has also already had several chances on probation and was not able to successfully complete those. And he is a self-admitted gang-affiliated member with the Gangster Disciples. It's for these reasons, Judge, that we're asking you to sentence him to prison.
All right, defense.
And Your Honor, I believe we had already given argument, but just a brief recap. He's learned his lesson. I believe this offense occurred in January, excuse me, of 2021. He's been monitored ever since then. He's been doing well, which is a demonstration that he can satisfactorily complete probation. His family relies on him to help provide for the family in addition to childcare. His girlfriend and 2 children are there because they're in the car or outside the courtroom because she had to take off from work so that she could care for the children while he came to court. They alternate caring for the children. As per the support letters, he is well liked by family and friends and in the community. He has been extremely pleasant and cooperative and extremely respectful with me. He is very, very remorseful. And I believe I told you about the shooting incident where he and his dad were shot, and which was the reason he had the gun, but he knows he was wrong and he's extremely remorseful. And he's asking that the court please give him an opportunity on probation. And, if he fails, then prison is always an alternative. I'd ask that you please give him an opportunity and consider that he is trying to turn his life around and has been doing so for at least the last year.
All right. Court will deny the defendant's application. Court will sentence you to 3 years in the prison, give you credit for any time served, taking consideration 2021 CR 3214. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? All right. Mr. Gordon?
Yes.
Did you review this document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of the definition of weapon or ammunition, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Gordon.
Excuse me, Your Honor.
Yes.
What was the sentence? 3 years?
3 years.
All right, thank you.
All right, you're welcome, Mr. Gordon. You're going to have to do better next time.
Yes, Your Honor.
Your Honor, before he goes, can I please have the number for his wife, if he could give that to me brief, so I can call her and let her know what's happened?
All right, I'm going to send you to breakout room number 1, and they'll give that information to you.
Thank you, Your Honor.
Thank you. Have a great rest of your day.
Did you hear? Yes.
All right, Edward Schroeder. You're on mute.
There, we did it.
Hi, yes.
Edward Schroeder for Justin Somerset, Your Honor. We're here
Yes.
for trial.
All right, do you know if this, who is the state on this case? On Justin Somerset?
I forget the gentleman's name. I talked to him 30 days ago about reducing the charge to a.
But no, was it Marcus Sanders? Who was it?
Ma'am. That was yes, Your Honor, Marcus Sanders.
All right, Mr. Sanders, have you all had a chance to speak with the complainant in this case?
Judge, he's getting back to his desk right now. Just a second.
Okay, no problem.
When I talked to him last week, last month, he was going to review the.
Yes, sir.
File.
All right, so Mr. Sanders,
Yes, Judge.
I'm going to send you to a breakout room with Mr. Schroeder because the last thing I have in the court's file is that the state was going to speak with the witness.
Yes.
All right, so Mr. Schroeder, thank you for your patience. I'm going to send you to breakout room number 3, and Mr. Sanders will meet you in 3. All right, Mr. Cortez, you're back.
Judge, may I please be put in the breakout room with Mr. Garcia, Judge, please?
All right, he's actually in breakout room number 2 at the moment. So as soon as he finishes in number 2, I'll place you in a breakout room. Just remind me.
Yes, Your Honor. Thank you so much.
All right, this is the last case I believe I'm going to take up. Then I'm going to take up the matter in the courtroom. Mr. May, who do you have? Mr. Barnes?
Yeah, Judge, I have Mr. Robert Barnes.
And who is the prosecutor you're conferring with on the bond?
Judge, to be honest with you, I have not visited with any prosecutor, to be honest with you.
Okay, just one moment. Mr. Groomer, this is a aggravated robbery, or either Ms. Sparks, are you able to confer with Mr. May?
I can talk to Mr. May.
All right, Mr. May, I'm going to send you to breakout room number 4.
Okay.
Let me see if I can find you on the Zoom. Just one second. I see you. All right, I sent you to number 4.
Thank you, Judge.
Sure. Yes. All right, Mr. Garcia, Mr. Cortez would like to speak with you. I'm going to send him to breakout room number 1. And everyone, just give me a moment, please. All right, Mr. Torres, can you unmute for me, please?
Yes, ma'am.
All right, your attorney is not here. We're going to get you another attorney. If you're okay with that.
Yes, ma'am.
All right, so we're going to recall your case for Monday and we'll have another attorney for you. So we'll give your attorney, your previous attorney is court appointed, but I know he hasn't been able to meet with you. So we are going to try it one more time on Monday. And if he's unable to make it, then what we'll do is we will have another attorney appointed for you, okay?
Yes, ma'am.
So we'll see you back on March 21st.
All right. Have a nice day.
All right, thank you. Thank you so much for your patience. And then Fernando Cortez, you are back.
Yes, Your Honor, I'm sorry, I feel like a boomerang, I'm back. But Mr. Garcia has reviewed the motion, Judge, and he said he forwarded, and I can see that he forwarded my motions and orders to you, Judge.
Okay, just give me one moment.
Yes, Your Honor.
All right, those will be signed, Mr. Cortez.
Thank you so much, Your Honor.
Thank you.
Thank you.
All right, Mr. May, who do you have? You're on mute. All right, who's the prosecutor on Barnes?
It was me, Judge.
All right. He's filed a
Ryan.
motion. Ryan, is there an agreement or no?
Judge, and I guess Charles is still on mute, but I think we have come to a proposed agreement. I think he's going to file a motion with that agreement that we agreed to a $60,000 bond with GPS allowing Mr. Barnes to go to school in the event he makes the bond.
Yes, Judge, that is correct. On the GPS, Judge, I would just ask the court to waive the fees on the GPS. My client is a student in high school, Judge, and mom's a working woman, and she can't really afford, the $60,000 bond plus the GPS, Judge.
So are we going to do partial GPS and he's only allowed to attend school?
That's what I would ask, Judge, just based on the nature of the charge.
All right, so I do have your order, Mr. May.
Thank you, Your
So
Honor.
Mr. Barnes, you're going to be allowed to travel to your high school and home. So
Yes, ma'am.
that's why that's the reason for your GPS to be partial. So that's the only places you're allowed to go. If there's something else involving your mom, where maybe your mom has to go somewhere and she wants to include you, you need to let your mom know, and you need to know that you'll have to contact GPS, and then GPS will contact me and let me know if I approve of that. Do you understand?
Yes, ma'am. Would they give me a number or?
Yes, they're going to give you all of that information. So let me put on here, and $60,000, correct?
Yes, Judge.
Are there any other no contact orders?
Judge, we actually can do that. I don't know if that was part of the original.
Judge, no contact orders would be fine, Your Honor.
I found it handwritten. Let me see. Judge, I have a victim by the name of Jose, Jose Gonzalez with a Z.
All right, and there's to be no contact with Jose Gonzalez. Do you understand?
Yes, ma'am.
Are you involved in any extracurricular activities at school?
Yes, ma'am.
And that would be what?
Play football.
All right, I don't know if they're going to allow you to play football with this charge. So before you, do that or think you're going to be in football, you need to get proof to pretrial services. And Mr. May, I'll need proof that he's actually being allowed to continue to play football.
Yes, Your Honor.
So, Mr. Barnes, your bond is going to be set at $60,000. There's to be no contact with Jose Gonzalez. You're allowed to attend school. I'll ask that the GPS fees be waived. So that's all you're allowed to do. Do you understand?
Yes, ma'am.
And
Your
do
Honor-
not be inviting people to your mom's house because you feel as though I'll get around this by just having people come to my mom's house. Make sure you follow your mom's rules. Do you understand?
Yes, ma'am.
And Your Honor, if I could, please, could we go ahead and do a no contact with the co-defendants also, Your Honor?
All right. And who are the co-defendants, Mr. Groomer?
Judge, that is a good idea. Thank you, Mr. Mace. Jacob, but it's spelled Jakob. And then the last name is Yantis, Yantis.
Okay. And there's only one co-defendant?
Yes, Judge, there were,
Judge, I would also ask for Ms. Crisela, Krisel Rodriguez, and Ms. Armani, Armani Sanchez. But they have no contact with those individuals.
All right. So you're not to have contact with Jacob Yantis, Crisel Rodriguez, and Armani Sanchez. Is there anyone else?
I think that fits it, Judge. Those last two were not charged, but they were kind of involved. They were very close to being charged.
All right. Then if there's nothing else, that has been signed. And Mr. Mays, if you want this set for anything else because he's not been indicted, you'll just need to contact Ms. Ferguson.
Thank you, Your Honor.
All right. Thank you so much. Do you need to speak with Mr. Barnes?
Yes, Your Honor, if I could, please.
All right. I'll send you to a breakout room with Mr. Barnes. And then after you finish conferring with him, make sure he comes back to the main room, okay?
Yes, Your Honor.
And let me find Mr. Barnes. Mr. Barnes, I'm going to send you to breakout room number 2. And Mr. May, I'll send you to number 2.
Thank you, Your Honor.
All right, who's the, yes? Somebody call my name? All right, who is the person who was conferring with Mr. Anthony Zamora?
I think it was Joe Ray, Judge.
Yes, sir. Yes, ma'am. It's Mr. Garcia.
All right, Mr. Garcia, did you have a chance to confer with Mr. Zamora on his motion?
Yes, I did, Judge. And there was 2 motions we discussed, motion to travel and the motion to amend conditions of probation.
Okay, and what is the defendant's name?
Louis Tapia. It's 2019 CR 13-18-3.
All right, and where is Mr. Tapia?
He's there, Judge. He's been there since 2.
All right, yes, Mr. Garcia?
Yes, Judge, we're not opposed to the motions. We're in agreement.
Mr. Zamora, the court has its rules and those are the court's rules.
I got a little taken aback, just surprised, Judge. I think this is my first motion of this type in front of anyone on a permission to travel, and I'm still thinking of the way it was 2 years ago, which was a long time ago.
I always require that the state and the defense confer.
And on all things we do, Judge, I was explaining that to Mr. Garcia. I didn't realize I had to do it on a permission to travel, but now I do.
Because I thought it was a little bit disrespectful.
My apologies. I was a little surprised, so my apologies to the court.
All right, so what are we doing with his case?
Well, Judge, we're asking the court to allow him to travel for his daughter's wedding.
No, I'm allowing him to travel, but
okay.
Is there
on the
anything
other one,
else?
Judge, yes, Judge, on the amended, he's gone through a partial loss of 1 foot through diabetic conditions, and he's using a prosthetic cast now. And they've got him going every Monday to report, all 5 of them. There's nothing coming up that they're not aware of because he's on medication as well. And so what we're asking the court to do is just allow him once a month. It's going to save him a tremendous amount of time. And I know this really doesn't have any impact on anything. Judge, I took this pro bono, this motion and this hearing. I did this because this gentleman needs somebody to at least speak up. So, because what they're having him do right now is a real burden with his medical condition. And so we're not asking him to stop taking them. We're just asking the court to inform the probation that once a month is okay.
All right, and state you have no objection to once a month?
No, the state doesn't, Your Honor. And as his probation officer, so far there hasn't been any violations and there's no objection from the PO.
Okay. All right, Rebecca, do you need to speak with him?
No, well, actually, yeah, just so I can get the travel dates, or if I can just get a copy of that signed motion.
Yes, officer, it's the 24th through the 28th on the motion. He actually comes back in late on the 27th, but we included the 28th because of his physical condition.
Anthony, sorry.
And in case something comes up. Yeah.
The motion says 25th.
25th through 28th?
Yes.
Is that correct, Mr. Tapia?
That is correct, sir. I'll send you out a breakout room number 1 and you can speak with Ms. Reyes.
Okay, thank you, Judge. Do I need to, may I be excused?
Yes.
Thank you, Judge.
You're welcome. All right, Mr. Garcia, on the Trevino matter.
Yes.
I see where you said you agreed. So you agreed to the no harmful or injurious?
Yeah, I don't believe those are conditions on the remaining cases.
Okay. All right, thank you.
Thanks, Judge.
Sure. And then to the persons in the courtroom, just give me one moment. Mr. Mays, you're excused.
Thank you, Your Honor.
All right, Norma, you can let them know that Mr. Barnes can go back. And then, let me see, what are they doing on Somerset? Just one moment, I'm gonna come out into the courtroom.
Joe Ray, can I see you in a breakout room?
Sure. What number?
1 is fine.
Everyone, thank you so much for your patience. All right, we're gonna go back on the record in 2021, C I-13023. If I can have parties announced, please.
Yes, Your Honor. Olivia Thayer and Jacqueline Janice for petitioner.
Charles Martin, Justin Morgan for respondent, Joaquin Rivera, and Joaquin Rivera is in corporate as well.
All right, and for the record, this hearing is taking place outside the presence of the jurors. Please be seated. It makes it, I know, usually everybody rises when they talk to the court, but actually it makes it easier for everybody to pick up everything on the microphone if you remain seated. So even when you're making your objections, I know it's going to be hard to do because that happened to me all the time on the civil side. If you remain seated, it will make it easier for everyone to hear. And trust me, I will not take that as a sign of disrespect. So my understanding is both parties or one party had motions, is that correct?
Yes, Your Honor. I believe both parties have just at least a few motions in limine, and Mr. Martin and I have spoken and come to an agreement on several as well.
Okay, so which motions in limine?
I don't know if the court prefers to start with petitioners or respondents.
Let me see what I have, just one moment. I have the petitioner's motion in limine. Petitioner's proposed charge and petitioner's exhibit list. I don't have motions in limine for the respondent. Does the respondent have any motions?
Yes, Your Honor, I will, may I approach?
Yes. And if you don't have copies, we can make some.
No.
Here's the motion in limine and proposed to charge. And then we also, during the trial, we'll ask for 705 limiting instruction. So I'll just give you that now. And we'll, because I'm sure we'll talk about it. But when the expert talks and goes into underlying facts and data, we ask for that 705.
Sure. All right, so petitioner, we'll start with your motion in limine.
For the record, and Mr. Martin, tell me if I'm wrong, I believe we are in agreement on numbers 2, 3, 4, 5, 7, 8, 9, and 10.
I agree.
So let's start with number 1 then on petitioner's motion in limine.
So this is just addressing basically collaterally attacking any of the judgments. As the court is probably aware, we have to prove that Mr. Rivera has at least 2 convictions for sexually violent offenses. And there'll be judgments reflecting that. Usually during the course of testimony, we ask about those offenses. So this is just getting at like any kind of going into the plea bargain process, going into attacking the victim's credibility, stuff like that, that just kind of collaterally attacks these judgments. These are final, they've gone through the system, and this is not the proper forum to be attacking them.
Let's find it.
I anticipate that the petitioner will offer into evidence the penitentiary packet, which has the judgments. On the face of the judgment does talk about the plea agreement, if there is a plea agreement. So that I think would come in automatically through just the black and white copy of that document. The other issue is that plea bargains and we'll put it this way, if a lot of information is going to come in as hearsay information from experts, not everything was pled to as far as things that are alleged. And those issues are not, talking about those or attacking those is not going to be collateral estoppel. However, I wouldn't offer anything to attack the convictions. I anticipate that that's not going to be an issue as far as the convictions, proving them up. We're not going to challenge the convictions. The only thing would be if there is reason to go into some of the underlying facts and data with the expert or the plea bargain.
All right, with regards to number one, respondent, before questions are made, if you'll just approach, if you're going to enter the territory that is encompassed by number one, because I won't know what my ruling will be until I actually see the judgment and hear where the evidence leads us.
Yes, sir.
All right, and then with regards to number six.
Number 6 is talking about any other form of treatment, supervision, or housing that would be more appropriate for the respondent other than civil commitment. So the jury is here to answer one question, whether Mr. Rivera is a sexually violent predator. And those two elements that are clearly outlined is the repeat sexually violent offender and the behavioral abnormality. Our expert has reviewed information regarding treatment that Mr. Rivera has had, but to say that basically civil commitment isn't for Mr. Rivera is to get into the effect of the answer, which we would argue we shouldn't be getting into in front of the jury. That becomes misleading and confusing to them. They don't need to know what happens after they give a verdict. The law is very clear. If it's a no, he's released, and if it's a yes, he goes to commitment. There's no real middle ground, unfortunately, under the law. So to get into treatment, whether civil commitment is for him or not, or whether there's better treatment out there than civil commitment, that starts confusing the issues. It's a slippery slope, and it's not really relevant to the question that the jury's going to be asking.
And Your Honor, the the expert will talk about treatment that Mr. Rivera has been in. That treatment stopped when he bench warranted in for this case to county. The problem that I have is when their experts will say that the person has not grasped the treatment concepts, needs more treatment, needs additional treatment, needs more intensive treatment. Those are the areas that I think opens the door for me to be able to go into things like parole parameters, mandated sex offender treatment under intensive supervision, and the availability of it in the community.
All right, well, with regards to that number, if you're seeking to ask questions about that, just ask to approach first, because I won't know my ruling on number 6 until I hear the evidence.
Thank you, Your Honor.
Yes. Right, and then we have number 11.
Yes, Your Honor, this kind of basically saying that any statement or suggestion that, this law is referring to or reserved for the worst of the worst, and that the respondent does not qualify. The worst of the worst is not a description we're required to prove. And it starts comparing him to others. It starts putting in the jury's minds, well, what else have I seen and outside of this courtroom that comparing him to other sex offenders they may know on their own in their private lives. And again, the jury's asked one very specific question, whether Mr. Rivera is a sexually violent predator. The two elements are very clearly defined in the law, and this description is not part of either of those definitions. So I would argue it would be very confusing to the jury.
All right, respondent.
Yes, Your Honor. Wide latitude is given to attorneys to argue their case during closing argument. If I were to go in to say something about the worst of the worst or doesn't qualify, one, I wouldn't say doesn't qualify, but that goes into argument, and I don't like it when argument becomes limited unless it's unless the argument is just overly.
Isn't 11 though concerning eliciting evidence from witnesses and not
Yes, Your Honor.
your argument per se?
Yes, Your Honor.
Well, it's any statement or suggestion, and I took it as it was arguing it. I don't think anybody is going to be able to testify to that. But the one thing that I do think is important is the legislative findings, which has been found to not be relevant to go into on our part, specifically states that this is aimed at a small but extremely dangerous group of sexually violent predators. And
But counsel, let me ask you, no, let's stay with number 11.
Okay.
So in number 11, what it appears from my reading of what the petitioner has placed is they are asking that no evidence be elicited from a witness. It's not necessarily your closing arguments, but they're asking that no evidence be elicited from a witness that this is not the worst of the worst language from a witness.
Okay, I see at the bottom.
So do you have any objections to number 11?
No, Your Honor.
All right, so 11 is agreed to. Number 12.
Number 12 is just kind of getting at testimony or eliciting testimony regarding this primary purpose of victimization, and saying that it's not there because respondent is opportunistic, just because he's not, for instance, driving a van around and throwing kids into it, raping them. He's somehow not, the primary purpose is not victimization. We do have case law and recommitment of Bernard. It is not from the perspective of the respondent that this victimization is seen. It is the perspective of the victim. And that is encompassed in behavioral abnormality, it's encompassed in the law already. And so to elicit any kind of testimony would be very misleading and confusing to the jury when I can't explain the case law to them. Because obviously I can't put case law into evidence.
All right, respondent?
Yes, there's only going to be two witnesses in this case. There's going to be Dr. Jason Dunham, who's a psychologist, and there's going to be Joaquin Rivera. Obviously, I'm not going to ask Joaquin Rivera about primary purpose of victimization because he's not a psychologist. So the only time this would come through would be through the testimony of the state's expert who was making an opinion on a behavioral abnormality. Some of the things used and some of the tools used directly point to what is the motivating factor for the person that has committed sex offenses and is likely to commit sex offenses in the future. If that expert goes into areas of that nature, I think what that does is look at being able to ask that question. The idea that a victim is not going to be defined by the person that committed the offense is not what we're asking. We're not asking Joaquin. It would come through an expert who is an expert in the field of understanding the human mind.
Well, Your Honor, it's a legal issue. Primary purpose of victimization, sorry.
No problem. All right, with regards to number 12, if there are going to be any questions about victimization, I'm going to ask that you approach first.
Yes, Your Honor.
All right, because I don't know what the testimony is going to be at this point. So just so the record is clear, on number 1, you're going to approach. If you want to ask any questions related to that, 2, 3, 4, 5, 7, 8, 9, and 10, and 11 is agreed to. Number 12, you're going to approach. And number 6, did we discuss number 6?
We did.
All right, okay, on that one, you're going to approach as well. All right, any other motions from the petitioner?
Not the same, Your Honor.
All right, defense.
Yes, respondent has a
I'm
motion.
sorry, I keep saying that, but yes, respondent. All right, your motion in limine.
And we've agreed to number 1, number 4, number 9, number 12, number 13, and number 16. Is that correct?
We also agreed at 2, 3, and 17.
All right, let's start with number 5.
So the mugshots of the respondent, I'm not anticipating waiting around or anything. They're just in penitentiary packets, which I plan to offer into evidence through that first element. They're part of the identification of Mr. Rivera. And it's my understanding we can't take apart those pin packets. So it's just part of the identification, and that's the only way I anticipate them coming in.
All right, respondent.
Yeah, technically the mugshots are not relevant. I mean, they're prejudicial in that they depict the client in prison attire. And they're also from various ages, not necessarily how he is today. But
is it a part of the pin packet?
It is a part of the pin packet, and as long as it's not going to be in a PowerPoint or waved around, I am fine with it being submitted in an exhibit.
All right, then. We'll move on to number 5. Are you waiving that from your motion in limine or withdrawing it?
Well, I don't want to waive it because I don't know what will happen. But if they were to put that, say, up on a slide or in a PowerPoint in a closing argument, I would object to it and approach, and then it would still be on the. I still think that it's highly prejudicial to have the mugshots shown.
All right, that's going to be denied. It's a part of the pin packet. And the pin packet is a business record, and you cannot tear it apart.
Okay, Your Honor. Thank you. Should we go to 6?
Yes.
Number 6 is discussing details of any sexual offense that respondent has been convicted of, other than the act itself that amounted to the criminal offense respondent was convicted of, including but not limited to details about the events taking place immediately after the offense. So the state has to prove 2 things. The first part of that is that he's a repeat sexually violent offender. They can do that without going into the additional information not related to the sexual offending that was the root of the conviction.
All right, petitioners.
Yes, Your Honor. This more goes towards the behavior abnormality element. Dr. Dunham is going to need to talk about the details in the sense of this is where equals its risk factors. Under the Texas Rules of Evidence 705, it does allow for experts to discuss underlying facts and data so they can explain their opinion to the jury. As we all saw, during Rhode Island, this is kind of a weird case. And so Dr. Dunham needs to be able to fully explain why he found the behavior abnormality present. These risk factors that he's going to talk about come from the details of these offenses, and they are research-based. We also have case law on point. It's an email, but I also have the sites here regarding that case law if the judge would like it.
All right. With regards to number 6, just approached before, because I see that the respondent is making his request for the motion in limine under 705D and under 403, and I cannot do 403 until I hear everything.
Yes, Your Honor.
Number 7 is very similar. It's any mention of any unadjudicated offenses. And number 8, we can look at the same time as well, because it's any mention of any sexual allegations that have not been substantiated. In this case, there was a dismissed case that it's, to me, discussing a dismissed case in this instance, and it was an accusation of a sexual assault of an adult female, not a child, is confusing the issues. And it also is potentially confusing to jurors when we're looking at a civil case in this manner.
So 7 and 8, those are there because you are concerned about a case that was not, that was dismissed.
Yes,
Is that 7 and 8 is solely related to the case that you're speaking of that was dismissed?
Now, there could be other, there could be other allegations within those offenses that were not adjudicated. That's where we go into, whether or not these facts, the underlying facts and data become a part of the conviction or are, kind of left there. Just no, when you're plea bargaining, sometimes things drop off. You plead to one thing, certain things aren't addressed, or certain things may be dismissed or taken into consideration.
To the petitioner, are you planning on this case that the respondent is speaking of that was dismissed? Are you planning on going into dismissed cases?
There's one case that was charged and dismissed. Dr. Dunn, it goes towards the static 99R that he scored. It says in the records it was dismissed because the victim was incompetent. She was deaf and mute, so she could not testify. So I talked to my expert again. I'm like, do we need to go into this? And he said he has to go into it for the static because Mr. Rivera gets a point on that for the static based on the charge. But we will, of course, I will have him flesh out. This was dismissed. He was not convicted. But to explain that static score, that's.
All right. So what we'll do, respondent and petitioner, when that matter is going to be brought up, just approach, and then the court will make its ruling.
Yes, ma'am.
Thank you, Ron.
Number 9.
Number 9, I believe we agreed.
It's agreed. It's not so. It's agreed to.
And number 10 is any mention of a behavioral abnormality assessment or the results of a behavioral abnormality assessment not performed by the testifying expert. So in this case, you're going to have one testifying expert, Dr. Jason Dunham, who stated in his deposition and will state, under oath, that his methodology is to take that MDT report and put it to the side. He doesn't look at that MDT report. He looks at all of the information that would have been available to that expert, and then he makes a preliminary determination and then looks back at the MDT report. So he's not relying on it for his ultimate opinion. He's only looking at it as a after the fact deal. His opinion is based on the facts and data that were available to the other person and all of the other facts and data presented to him. By allowing another expert who's not here to testify to be able to, basically come in here without being able to be cross-examined and have an opinion is inappropriate. And it's also substantiated by Dr. Dunham's testimony of how he puts it to the side.
Your Honor, Dr. Dunham mentioned in his deposition that he may put it to the side, but he still considers it. It's still data and facts reviewed and relied upon. And it's not just Dr. Thorne's opinion that he's reviewed and relied upon. It's the statements that Mr. Rivera made in that report that's also relevant. Again, it also goes towards Dr. Dunham's trying to get as accurate a picture of Mr. Rivera as possible. And what Mr. Rivera is saying to different people over time is very relevant to either how he's progressing in treatment, how he's doing his offenses, whether he's a pathological liar, which is not the problem in this case, but just to give an example, it's not just the opinion, it's also the statements made within those reports. And we do have case law on this in recommitment of Richard Barnes out of the 4th Court of Appeals and in recommitment of Ramirez also out of the 4th Court of Appeals.
The respondent is basing number 10 on 705D and 403, and the court cannot make a ruling on that until I hear it to make the ruling as it relates to 403 of the rules of evidence. So just approaching the court will make a ruling.
Yes, Your Honor.
Thank you, Your Honor.
And I think number 11 goes with that. Is that right?
Yes. Any mention of the probable testimony of a witness who is absent, unavailable, or not called. I anticipate that Dr. Dunham will testify that he's never called the MDT person to ask him his opinions. So anything that comes in through that report is going to be testimony of an absent, unavailable, not called witness.
Are you saying that an expert witness is going to testify to what the probable testimony of another person would have been?
The expert in these situations will, under the guise of reviewing and relying on records, will present in front of the jury hearsay evidence, including statements made in that MDT report, multidisciplinary team report.
But I'm just trying to figure out, are you saying an expert is going to come in and testify? I'm used to experts reviewing of someone else's work and testifying based upon work that they've reviewed. But I've never had an expert to come in and say that if expert B were here, this is what expert B would say. So I'm trying to figure out from your number 11, are you saying that you anticipate an expert witness is going to come in and testify what they think someone else's testimony would be?
Well, since the report is the testimony of that expert that's not here, the MDT report, like let's say if Dr. Jason Dunham is using that to say he's a compulsive liar, and he's saying that this statement made in this document to this expert who's not here is proof of that, then yes, he's testifying to what someone else outside of this courtroom has said.
Your Honor, I do not anticipate Dr. Dunn coming in and saying, if Dr. Thorne were here, he would say X, Y, and Z. He's basing his opinion on everything he's reviewed and relied upon. It does include a report by Dr. Thorne. So, if he says something regarding that report, I would argue it falls under 705, of the Texas Rules of Evidence, and that it may be hearsay, but this is an exception, and he's allowed to talk about it.
All right. I'll have you all approach on number 11 if that were to occur. I've just never seen an expert who comes in to say that if another expert were here, this is what he would say. And that's what number 11 seems to be saying to me. But I'll make a ruling on that if it occurs.
Thank you.
All right, number 12.
12 and 13 were agreed.
Yes, number 12 and 13 are agreed. Yes, sir.
14 is any reference to respondent needing sex offender treatment, additional sex offender treatment by an individual who's not a licensed sex offender treatment provider or not treat, well, and it doesn't say it, but or not treating the individual for sex offender treatment.
All right. On that one, I'll have you approach because you have it under Rule 4.3, and I won't be able to make a decision on that until I hear the evidence.
Thank you, Your Honor. 15 is any mention of the multidisciplinary team's process for selection for civil commitment. This is not relevant. It's also under 403 and 705 prejudicial, more prejudicial than probative, because the question is not about what this multidisciplinary team process is. It's about an individual who they're going to hear, an expert, and they're going to hear the testimony of Mr. Rivera. Any trying to use the multidisciplinary team process is an attempt to try to show that he is part of the small but extremely dangerous group, but then we're not allowed to go into what the state means by a small but extremely dangerous group of sexually violent offenders.
And Your Honor, I only anticipate this coming up. Dr. Dunham has done a number of these evaluations, and because there is a screening process in place, he has found a behavior abnormality present more often than not, because he is typically the second evaluator. So there's already been a screening process done. So the only thing I anticipate getting into with this is to explain, it goes towards his credibility, to explain why there is a discrepancy in number towards more he's found VA present more often than not. And that's as far as I take it, Dr. Dunn, is there a screening process? Yes, you're not the first evaluator, yes, and move on. I don't anticipate getting into the details of this multidisciplinary team's process.
All right, any objections to that being the line of questioning respondent?
Yes, by going into, is there a screening process? You're not the first expert to review him. Puts in front of the jury the fact that there is this additional expert out there that is not here.
All right, what we'll do is we'll approach on that one because I see you have it under 4.3. Right, next, number 16, that's agreed to.
Yes,
Yes, Your Honor.
as is 17.
Yes. 18 is any mention of the actuarial assessment or testing for psychopathy that was not performed by the testifying expert. This goes again to the multidisciplinary team report, which is going to talk about an actuarial assessment and a testing for psychopathy done by a different expert. And again, Dr. Jason Dunham has done his own scoring of those instruments based on the records reviewed.
All right, again, respondent has this under 4.3 as well, so just approach on that matter.
Yes, Your Honor.
And number 19?
19 is any mention of any actual or alleged gang involvement on the part of respondent. There is evidence of gang involvement, but it stopped in 2001. I believe that bringing up any information on gang involvement that ceased in 2001 would be highly prejudicial, and it's not really probative to whether or not the person has a behavioral abnormality as he is today.
And Your Honor, this goes towards Dr. Jones going to testify that Mr. Rivera has antisocial personality disorder. The gang activity goes into that, so it helps explain why he found that disorder present. Also, he started participating in a gang when he was younger, and that disorder becomes a disorder when there's evidence before a certain age. I think it's 15, and so that goes into it, as well as he may have stopped participating in a gang in 2001. However, Dr. Dunham has to look at his whole life, as we heard from jurors today in Nevada. They want to hear how much information Dr. Dunham has looked at, what's all gone into his opinion. This is something very relevant. It goes towards antisociality, and it shows the jury that Dr. Dunham's not just looking at, oh, he has 2 convictions for sexual offenses, I must have a BA. No, he's looking at everything, including the good, including the bad.
All right, on that one again, the defense has placed it under 705D and 403. So before that's entered into, I'll make a ruling.
Yes, ma'am.
Thank you, Your Honor.
All right, is there any other motions?
No, Your Honor, but I will just take a few minutes to tell you that we did file that requested hearsay and Texas Rules of Evidence 705D limiting instruction. So if the expert is allowed to go into the underlying facts and data, I will at that time ask for the jury to be instructed on that.
And there's no objection from petitioner, just a heads up on that as well.
Right.
Not read.
All right, is there anything else?
Not from petitioner.
Nothing from respondent.
All right, we'll go off the record. I received the proposed jury charge from each of you. Did you all receive the jury charge recommendation from the staff attorney or no?
I don't believe so.
I did not.
All right, so I'll make sure that Ms. Ferguson emails that to both of you.
Sounds good.
And I think what she did was she took the proposed charges, but my understanding, you all just tried a case in another court here. And so she's probably using that charge, but she did say she was going to add something extra. I believe this is it. Just one moment. All right, I'll have her email it to you both.
Thank you.
All right, thank you. I'll see you tomorrow at 9 a.m. And if you still need to speak to your client, you're more than welcome to speak to your client.
Okay, thank you.
Should I just bring my flash drive that I had to at my laptop? The last time
There we go.
Sorry, Judge, are you?
Mr. Sanders, can you hear us?
Yes, I'm not sure if the court is still is doing something.
All right. Mr. Sanders and Mr. Schroeder, what is happening with your case?
Judge, this is one where at the last setting, defense provided us with a number for the victim who we have been unable to reach. We've got in contact with him, but we haven't been able to have a conversation with him. He was at work, and so he asked us to call him back. So we need a little bit more time, but based on our conversations, it seems like a case that we will probably be able to work out.
All right, so Ms. Ferguson, can I have a 3-week reset? Is that enough time, Mr. Sanders?
Yes, Judge.
All right, so Mr. Schroeder, I'm going to give you a 3-week reset. Ms. Ferguson, if you can put that in the chat box, please. And everyone, I'm going to stop live stream. We can start. We're going to